The following is a chapter from my book, Sexual Trafficking in Children, where I discuss the judicial response. Chapter 7. Sexual Trafficking and the Judicial Response. State and federal laws prohibit most forms of child sexual exploitation, including prostitution, molestation, procuring, sex rings, pornography, and the transportation of minors for sexual purposes. The extent to which these laws actually restrict the child sex markets by acting as statutory barriers between victim and exploiter, however, is debatable. In this chapter we examine the official reaction to the issue of sexual exploitation, as well as appropriate punitive responses to the crimes of sexual trafficking. The legislative response, statutory intervention and economic link between victim and offender is often forged when minors are excluded from legitimate employment opportunities. Indeed, a number of federal and state laws prohibit minors from acquiring any gainful employment. When legitimate opportunities do not exist, survival for children who lack the support of their family may depend upon entry into a commercial sex market. State legislators have long recognized the relationship between exploitation and the profit motive, as one legislative resolution of the Arizona legislature states. The production and sale of such child pornographic materials results in millions of dollars of profit, and the abundance of these materials in Arizona indicates that the state contributes substantially to that figure. The state legislature of New York has acknowledged the unhealthy relationship between exploitation and profit as a reflection of statutory failure to provide for juveniles at risk. Furthermore, it declared that the state has an obligation to break the bonds of economic exploitation associated with the sexual victimization of minors. The legislature finds that there has been a proliferation of exploitation of children as subjects in sexual performances. The care of children is a sacred trust and should not be abused by those who seek to profit through a commercial network based upon the exploitation of children. While many legislators clearly understand the need for action, not all legislation effectively addresses the problems of sexual trafficking. Vague language and overly broad coverage in state and federal laws have led critics to question whether such statutes are consistent with the provisions of state constitutions and the federal Constitution. Most challenges are based on alleged violations of the First, Sixth, and 14th Amendments, which guarantee, among other rights, freedom of speech, freedom of the press, the right to a speedy and public trial by an impartial jury, the right to be informed of an accusation, the right to confront witnesses, the right to assistance of counsel and compulsory process, and the right to equal protection under the law. As a general rule, nevertheless, a state's interest in ensuring the welfare and safety of children is deemed to take precedence over the possible infringement of an offender's constitutional guarantees. Judicial responses to constitutional challenges are based on past experiences with economic and social welfare legislation and on prior decisions in cases in the areas of child neglect, incest, sexual assault, and obscenity. These laws permit a state to intervene in a minor's life. A juvenile runaway, for instance, can be involuntarily placed under state supervision in an institutional setting. Although actions of this kind often raise the question of whose best interest is being served, they translate a child's entitlement to protection into concrete action. Like child abuse laws, however, sexual exploitation statutes are often viewed as an unreasonable assault on familial integrity and individual freedom. Substantive due process minimally requires, therefore, that intervention be reasonably related to the promotion of a valid state interest, in this case, the protection of a human resource. Advocates of intervention by the state in matters of sexual exploitation argue that such steps are justified because, in the words of Justice Herbert A. Pickford of the Supreme Court of Virginia, the state has a compelling interest, one central to its right to survive, in protecting children from treatment it determines is physically or psychologically injurious to youth. Defending the state's interest in this matter can be properly traced back to the development of child neglect legislation, the precursor of sexual exploitation statutes. Child neglect laws developed from the belief that the welfare of the child is of paramount importance and that the legal rights of the parent should be respected if the welfare of the child is not endangered. Similar concerns were expressed at the national level in Prince v. Commonwealth of Massachusetts, 321 U.S. 158, 64 SCT 438, 88 L.ed 645, rehearing denied 321 U.S. 804, 64 S.CT 784, 88 L.ed 1090. Justice Rutledge recognized that the state has an ongoing interest in protecting children against such abuse as might prevent their growth into free, independent, well-developed men and citizens. The Prince decision held that the state may constitutionally intervene in the parent-child relationship for the purpose of enforcing its child labor laws. Child neglect statutes have been criticized as overly broad when they focused on criteria other than a minor's condition, for example, parental conduct or character. Even then, as the U.S. Supreme Court observed in Sinsberg v. New York, 390 U.S. 629, 88 SCT 1274, 20 L.ed 2D 195, rehearing denied 391 U.S. 971, 88 SCT 2029, 20 L.ed 2D 887, the state has a more compelling interest in the protection of children than in the control of adults, parents. Because child welfare legislation is often based on intuitive and emotional assumptions, it is reasonable to suppose, in the words of Columbia Law Review editor Robert Buchholz, that the narrowest possible means by which the state could fully implement its interest in child protection would be a statutory formulation focusing on the child's condition and requiring a determination that the proposed state assistance would in fact benefit the child. Unfortunately, criteria deemed suitable for child neglect cases often fail to accurately encompass child exploitation situations. In this regard, laws meant to eliminate child prostitution and pornography, for example, have come under increased congressional scrutiny since the Ferber decision, in which the U.S. Supreme Court upheld the constitutionality of a New York criminal statute prohibiting the knowing promotion of sexual performances by children by the distribution of materials depicting such performances. Frequently, laws that govern sexual trafficking are inadequate in their protection of children. As stated by the federal judge for the Western District of Oklahoma in 1986. Such statutes are supplemental to other statutes readily applicable to activities associated with child pornography such as rape, incest, sodomy, child abuse, and neglect, contributing to the delinquency of a minor, indecent exposure, and obscenity. These other statutes are somewhat limited because some impose liability upon parents and guardians only, have relatively weak penalty provisions, outlaw physical abuse only, and are not only difficult to prosecute but are also low on the priority status of prosecutions in general. Hun. Lee R. West. This observation brings the central problem into focus. Legislators must make suitable legislation a higher priority. For, in the words of David Chauvelin, without the incentive of probable conviction, prosecutors are unwilling to prosecute, police are dissuaded from making arrests, and pedophiles, and others, are left to sexually exploit children without fear of reprisal. Congress chartered the National Child Labor Committee in 1907 to promote the welfare of America's working children, investigate conditions in various industries, and spearhead the push for state legislation. On June 24, 1924, Congress proposed an amendment to the United States Constitution banning child labor, which 28 state legislatures had ratified by 1937. In 1938 the Fair Standards Act was passed, prohibiting the labor of children under the age of 16 in most jobs and barring persons under 18 from dangerous occupations. Although it was intended to prohibit the economic exploitation of minors, the Fair Labor Standards Act inadvertently provided a variety of opportunities for adults seeking to profit from the financially disadvantageous situations of minors. Directed exclusively at the abuses of child labor in manufacturing, the Act left significant gaps in the protection of minors in non-manufacturing activities which were subsequently exploited by sexual traffickers. Since 1937, the bulk of federal legislation in the area of child protection has focused on child abuse and neglect, primarily within the family. In 1981, the U.S. Supreme Court granted a petition for certiorari in the Ferber case, which raised this question: to prevent the abuse of children who are made to engage in sexual conduct for commercial purposes, could the New York State Legislature, or any legislature, prohibit the dissemination of material which shows children engaged in sexual conduct, regardless of whether such material is obscene? The court responded affirmatively to the question, stating that child pornography, like obscenity, is unprotected by the First Amendment if it involves scienter, a defendant's guilty knowledge, and a visual depiction of sexual conduct by children without serious literary, artistic, political, or scientific value. Before the Ferber decision, 47 states and Congress had legislation specifically addressing child pornography. In the wake of the Ferber decision, Congress amended the Protection of Children Against Sexual Exploitation Act of 1977, passage of which was necessary because existing laws provided inadequate protection against the use of children as prostitutes or as the subjects of pornographic materials. The amendments produced 4 changes in prevailing federal law. The age of majority was raised from 16 to 18, pecuniary penalties were raised to $200,000 for persons and $250,000 for organizations, the commercial purpose requirement was deleted, and the obscenity requirement was deleted. The Legislative Committee concluded that since the harm to the child exists whether or not those who initiate or carry out the schemes are motivated by profit, the subcommittee found a need to expand the coverage of the act. The U.S. Court of Appeals for the 11th Circuit in 1985 found that the amended version, known as the Child Protection Act of 1984, did not violate the defendant's constitutional right to privacy. In 1986, Congress passed the Child Abuse Victims Act of 1986, which increased the minimum term of imprisonment to 5 years for an individual guilty of the sexual exploitation of minors. In 1984, Congress enacted the Missing Children and Assistance Act, which established a national clearinghouse and resource center to provide state and local governments, public and private nonprofit agencies, and individuals with technical assistance in locating and recovering missing children. As a result, the National Center on Missing and Exploited Children was created. Funded by the Office of Juvenile Justice and Delinquency Prevention, the center was directed to extend, among other services, assistance to state law enforcement agencies in investigating and prosecuting cases of missing and exploited children. The center is also responsible for maintaining a nationwide, toll-free hotline, and has orchestrated a variety of media campaigns designed to publicize the plight of missing children. One of the center's principal functions is to collect and disseminate data on the problem of sexual exploitation to state agencies. At the federal level, sexual trafficking has been addressed by legislative remedies which provide penalties but meager financing for state and private agencies. Sexually exploitive acts prohibited by federal statutes include child pornography, sexual abuse, and child prostitution. The Child Abuse Prevention and Treatment Act, 42 U.S.C. 5102 ETSEQ sets a broad federal standard to which state laws can be compared. This act, which has been amended several times since its inception in 1974, makes it unlawful for any person to employ, use, persuade, induce, entice, or coerce any child to engage in, or have a child assist any other person in the production of, sexually explicit or simulated conduct. This prohibition holds true for anyone, including a parent, legal guardian, or custodial adult who allows or knowingly permits a minor to enter into such a situation. Punishment for sexual trafficking. Debate continues over what constitutes appropriate punishment for child exploiters. Do fines and prison sentences reduce the level of trafficking? Is there a cause-effect relationship between severe punishment and reduction in the number of sexually victimized minors? There is not, at least presently, a sufficiently informed consensus to dictate definitive and comprehensive approaches. What can be agreed on is that the criminal justice system must provide speedy trials and that the punishment should be appropriate for the offense. To determine appropriate punishment, most states consider the nature of the offense, its degree of severity, the defendant's past record, and the extent of the defendant's involvement in the case under consideration. See Tables 7-1 and 7-2. The judgment can be substantial fines or a term of imprisonment. The latter course must, however, be considered in the context of the present prison overcrowding and the high cost of incarceration. Accordingly, it is most often adopted with violent offenders, that is to say, punishment is not likely to be severe unless the offense can be defined as having as an element the use, attempted use, or threatened use of physical force against the person or property of another, or any other offense that is a felony and that, by its nature, involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. Table 7, 1 selected state legislation showing upper limit of penalty, term of state, statute, and year of passage. California, sexual exploitation of children. Imprisonment, years fine $100,000. Florida, sexual performance of a child. Imprisonment, 15 years, fine, $10,000. Georgia, sexual exploitation of children. Imprisonment, 20 years, fine, $20,000. Minnesota, sexual exploitation of child or child pornography, imprisonment, 20 years, fine, $20,000. New Jersey, endangering welfare of children. Imprisonment, 10 years. New York, sexual performance by a child. Imprisonment, 7 years. Ohio, obscenity involving a minor. Imprisonment, 10 years. Pennsylvania, sexual abuse of a child. Imprisonment, 10 years. Tennessee, use of minors for obscene purposes, imprisonment, 21 years, fine, $10. Virginia, production, publication, sale, possession with intent to distribute, etc., of sexually explicit items involving children. Imprisonment, 10 years, fine, $1,000. This approach leaves in doubt the appropriate punishment of various other offenses that lack the ingredient of violence. Child pornography, for example, is a major element of sexual trafficking, yet lacks the element of violence that would result in incarceration for even a flagrant offender. In response to this circumstance, the courts have begun exploring new options. California, for instance, has established a pilot program for treatment of offenders who have sexually abused children. Initially, an offender is required to undergo counseling in conjunction with a probationary sentence. If he continues to abuse children or declines counseling, the sentencing court removes the probationer from the program, and the traditional sanction of imprisonment is imposed. At the federal level, criteria established for fixing an appropriate sentence include: 1. Age. 2. Education. 3. Vocational skills. 4. Mental and emotional condition, to the extent that such condition mitigates the defendant's culpability or to the extent that such condition is otherwise plainly relevant. 5. Physical condition, including drug dependence. 6. Previous employment record. 7. Family ties and responsibilities. 8. Community ties. 9. Role in the offense. 10. Criminal history. 11. Degree of dependence upon criminal activity for a livelihood. Federal statute. Federal statute. Importation of immoral articles prohibited 18 U.S.C. 1305. Penalty, seizure and disposition, 19 C.F.R. 12.40, 12.41. Federal statute. Mailing obscene or crime inciting matter 18 U.S.C. 1461. Penalty, maximum fine of $5,000 and maximum imprisonment of 10 years. Subsequent offense doubles penalties. Federal statute. Offenses committed within Indian country 18 U.S.C. 1153. Penalty of state jurisdiction. Federal statute. Penalty for mailing of sexually oriented advertisement 18 U.S.C. 1735. Penalty, maximum fine of $5,000 and maximum imprisonment of 10 years. Subsequent offense doubles penalties. Federal Statute. Child Sexual Abuse and Pornography Act of 1986, PUBL No. 99-628, November 7, 1986, 100 STAT 3510-3512, Section 2. Advertising offenses related to sexual exploitation of children. Fined and imprisoned for any term of years or life, or both. Federal Statute. Sexual abuse of a minor or Ward 18 U.S.C. 2243, Chapter 109A, Sexual Abuse. Aggravated sexual abuse, c. with children 18 U.S.C. 2241. Penalty, fined and imprisoned for not more than 5 years, or both, minor. Fined and imprisoned for not more than 1 year, or both, Ward. Federal Statute. Transportation of minors 18 U.S.C. 2423. Penalty, fine and maximum imprisonment of 10 years, or both. Federal Statute. Sexual exploitation of children 18 U.S.C. 2251-2252*. Penalty, maximum fine of less than $100,000 and imprisonment up to 10 years, or both. Prior conviction, maximum fine of $200,000 and imprisonment of 5 to 15 years, or both. Maximum organization fine of $250,000. See note below, star. Federal Statute. Criminal/civil forfeiture 18 U.S.C. 2253, 2254. Penalty, forfeiture of property subsequent to seizure by federal authorities. Between May 1977 and November 1983, only 4 persons had been indicted under Section 18 U.S.C. 2251, of whom 2 pleaded guilty to other charges under 18 U.S.C. 2252, traffic in materials portraying sexual exploitation of children, 1 pleaded guilty to conspiracy, and 1 still had proceedings pending. Report of the Judiciary Committee, House of Representatives, to accompany H.R. 3635, Report No. 98-536, at 2. 1984 U.S. Code CONC and Admin News 493. Of the 28 persons indicted during the same period for 2,252 offenses, 23 were convicted, 2 were convicted other obscenity violations, 1 defendant committed suicide, and 2 defendants were subject to pending violations, IBID. In the 28 months from May 21, 1984 to September 26, 1986, 274 individuals had been indicted and 214 individuals were convicted for federal sexual exploitation of children violations. Report of the Judiciary Committee, House of Representatives, to accompany H.R. 5560. Report No. 99-910. At 5U986. 1986 U.S. Code CONC and Admin News 5954. Careful consideration of these factors assists the sentencing court in fashioning a sentence appropriate to the circumstances and increases the likelihood of achieving the following fundamental objectives. 1. Protection of the minor victim in the case at hand. 2. Protection of potential victims. 3. Separation of the offender and the victims. 4. Rehabilitation of both the victim and the offender. 5. Action to prevent reoccurrence. This approach tends to provide alternatives to imprisonment. In 80% of the states and in the federal courts, the trial judge imposes sentence, jury sentencing is retained in less than a dozen jurisdictions. Under both modes, the dual objective of sentencing is apparent, the wrongdoer is punished and others are deterred from committing similar offenses. How the system works in practice: as previously stated, a stated right to intervene in a minor's behalf is well established. A point of considerable tension develops, however, when legislators and judges must balance the interests of minors against the constitutional rights of defendants. One way to measure the effectiveness of current statutory remedies is to consider how they were applied in an actual case of sexual exploitation. Clearly, not all victims benefit from the remedies theoretically available. The following case is an example of what happens when legal procedures are applied in the absence of judicial advocacy. It is a mother's account of her 9-year-old son's encounter with a neighborhood pedophile and the consequences of his victimization, both within and outside the formal judicial system. Taking the parent's point of view, the reader may answer the following questions, then evaluate the performance of the system in terms of the case's outcome. 1. What would I want the judicial system to do to ensure that my child's best interests and rights were represented? 2. What sort of penalties would I want applied to the offender? 3. What, if any, compensation would I expect for my child in the form of therapy and personal damages? 4. What consideration would I expect from the prosecutor and the judge in terms of minimizing my child's trauma during the pre-trial, trial, and post-trial phases of this case? A victim poorly served by the system. Jeff was our next-door neighbor, about 36 years old and a cook at a hotel restaurant. I really trusted him, never trusted somebody so much in my life. He never seemed to have any girlfriends, but I didn't ask why, cause it was none of my business. Jeff was good to kids, especially to Aaron. He had a yard, just a little old yard, and he'd give Aaron $10 to mow it. When I asked Aaron where he got the money, he said, "I got it from my buddy." That's what he called Jeff, my buddy. So I called Jeff up and asked him how come he paid Aaron, a 9-year-old kid, $10. He said he liked Aaron and figured he could use some extra spending money. He kept on giving Aaron money all the time. What a good neighbor. He'd come over, bring me the paper, take out the garbage. I've never known anybody nicer than he was. I discovered he had let Aaron drive his car. Other people had seen it. I mean, a 9-year-old driving a car? I found out about this later. Nobody told us at the time. Aaron liked him a lot. Sometimes he came over to the house to sit and talk with my husband and me about things in general. One night, around 9 p.m., Jeff stopped by to see if Aaron could spend the night at his house. I let him know that my son wasn't allowed to stay away from home. Still, we didn't think anything was really wrong. This guy would get upset, real mad, if someone else ever took Aaron out to play. Right then I should have been smart enough to figure him out, because he was always with my son. I just thought he liked him. It's my fault for not knowing better. I was working late the day it happened. When I came home, my husband, who is disabled, met me out at the car and said, "Kathy, Aaron's sick. He's been throwing up all day, ever since he got back from Jeff's." My husband kept asking Aaron what was wrong, but he wouldn't say anything. Anyways, he was just deathly sick, so we took him to the hospital emergency room. The nurse told us to go sit in the waiting room while the doctors examined him. We still didn't have any idea what was wrong with our son. Eventually the doctor came out of the examining room and told us what had happened. Jeff had had oral sex with my son. Aaron opened up to the doctors, but he refused to tell us. To this day, I don't know all of the details because Aaron is too ashamed and scared to discuss it. So we don't push it. When I found out at the hospital, I just sat there in total shock. I thought, what am I going to do? After all, I trusted this guy. My next-door neighbor. I almost went crazy. Jeff, of all people. For a little while my mind refused to believe it. After the shock wore off, they told me at the hospital that I had to get a warrant for his arrest. Which I did. And they put Jeff in jail on a pretty high bond. By the way, I had to take Aaron back to the hospital the second night. He was a nervous wreck. Let me tell you what it was like for him. He wouldn't eat, was sick for days, never could get to sleep. He'd stand in a corner all day long and blame himself, repeating, "It's all my fault, all my fault." Every time the phone rings, he'll say, "Mama, is somebody asking about me?" At first he cried day and night. When he finally went back to school, word got out about what had happened, and the kids would say awful things to him. God, they were cruel. I called the teachers at the school, but that didn't help much. When it first happened, I had a terrible time with him. You couldn't even mention the incident in the house or Aaron would burst out crying. I spent my whole paycheck to buy him a special bicycle, to help cheer him up since it was something he'd always wanted. He wouldn't play with it. Instead, he would just sit by himself and pick at his fingers. I knew what was on his mind. We took him to Baltimore for a vacation, but that didn't help. You cannot run away from something like that. Anyways, after Jeff was arrested, there was a hearing in closed court with the prosecutor, judge, and a bunch of people, grand jury, asking questions. Aaron didn't want to go in the courtroom. We had to practically drag him in. It broke his heart. They had questioned us one at a time, but they wouldn't let my husband or me sit in the courtroom with Aaron. Jeff had an attorney and said he was not guilty. Mr. Abbott, the prosecutor, represented us. The people in court asked me if I was a fit mother because I wanted to put my son through the pain of a trial. They actually blamed me for wanting to go to all this trouble to get the guy locked up. There never was a trial. We were supposed to have a preliminary hearing, but the prosecutor kept putting us off. This went on for weeks. We spent a whole day sitting in his office once and he finally came out and said, "Not today." Why not drop the case? Abbott told me that I should drop the case because Aaron would have to go through a bad time in court. At first I wouldn't do it. I told Abbott, if I drop it, what is Jeff going to do next? I was furious. Nobody cared if Jeff got punished. The prosecutor called up one day and said Jeff had pleaded guilty to the charge. He was willing to do anything they wanted except go to jail. So Abbott told me that if I agreed, Jeff would be put on probation and sent to the mental health center for treatment. I was against it, but Abbott said, once again, if you think your son went through hell at the grand jury hearing, wait till the defense gets him in open court. They'll tear him apart. Let it drop or take your chances in court. This was the choice he gave me. I still don't understand why I had to decide. Isn't a prosecutor supposed to make this decision? I sat up all night trying to decide what to do. My husband wanted Jeff locked up. Finally, I told Abbott, okay, drop it. The only reason I agreed to probation was because he gave me so much hassle about what the defense would do to my son in open court. I didn't think Aaron could take it at the time. I gave the prosecutor my home and work phone numbers and asked him to call and notify me of the outcome of the case. He never called or let me know a damn thing. I still don't know for sure if Jeff is on probation or what they did to him. To this day no one will tell me. The worst part is that we still run into Jeff. I've seen him. So has Aaron. About a week ago, we went to a store and Aaron suddenly took off running for the car. Jeff was in the store and Aaron saw him. My oldest son spotted this guy in town one day, jumped out of the car, and just about beat Jeff to death. Jeff tried to get a warrant issued on my son, but the prosecutor refused. When it first happened, my husband begged the police to let him go find Jeff and kill him. If the police hadn't picked up Jeff first, my husband would have killed the guy. No question about it. Aaron has calmed down since the incident, but any little thing gets him upset. The doctors said it would take years for him to recover, but he'd never forget what happened to him. School kids still tease him and he still thinks it is all his fault. He refuses to get help at the mental health center and wants to know why he has to go there if it wasn't his fault. What did he do wrong? Aaron is 10 years old now. He cries a lot. I try not to think about it too much. My husband and I never discuss it when he's home. But I'm his mother. I know it plays on his mind. He spends a lot of time alone, just thinking. Never ever talks about the incident. I don't think he fully understands what happened to him. I think I did wrong. I believe now I should have gone to trial, but this case just meant nothing to the prosecutor. This experience will stay with Aaron for a long time. Take it from me, and don't ever trust your next-door neighbor. The criminal justice system in this case obviously failed to address the problem of appropriate punishment. Instead, the prosecutor accepted a plea bargain that returned a child molester immediately to the community. No provisions were made to place either Aaron or his family in counseling or therapy as a result of this traumatic incident. Obviously, there are a number of important peripheral issues involved in this case, including sentencing as an appropriate expression of the state's perceived interest in the welfare of a minor. Judicial advocacy. The rights of an underage victim of sexual molestation are sometimes incompatible with the needs of substantive due process and the application of legal remedies. In Aaron's case, the mother assumed, correctly or not, that both victim and defendant were moved through the judicial process with a minimum expenditure of effort, time, and interest by the judicial officers. Judicial advocacy is more than just going through the motions of protecting underage victims. Alexander Lyerly, a district court judge with jurisdiction over certain types of cases involving exploited children, points out in the following case that judicial advocacy also involves the investigation, hearing, prosecution, and fair disposition of such crimes with full consideration for a victim's rights. Only in such a comprehensive approach will the response be appropriate and equitable to the needs of the sexually exploited child, while still ensuring the rights of the accused. A view from the bench. All children are potential victims of sexual abuse or exploitation. There is no minimum age. We deal with cases in which the victims are only a few days old. The significant majority of cases with which I have been involved have, however, concerned children who are in the prepubescent stage of physical/sexual development. Sexual exploitation of children may take any number of forms, from actual, definable sexual acts upon the persons of children, to private, traded, or commercial photographs and films, to the private or commercial prostitution of children. Victims come from all types of families. Both birth and step-parents, adoptive and foster parents are frequently the abusers. Professional caregivers in schools, group homes, daycare facilities, and even homes specifically structured to house and treat the abused child should be aware of the possibility that these places provide for staff members an excellent opportunity for exploiting children. Unfortunately, the public, medical, and legal professionals, law enforcement personnel, social workers, parents, and especially the courts often lack adequate skills to deal with every level of the abused child's needs. Children who have been sexually abused or exploited rarely fabricate the story. If anything, they tend not to relate it fully, especially if it is an isolated, rather than an ongoing, incident of abuse. Children simply lack the sexual and social sophistication to intellectualize an abusive or exploitive event. Some do, of course, but most do not. The exploiter often finds his or her encounters with kids to be more sexually and psychologically gratifying because he or she, as the abuser, can feel somehow superior to the child. The victim frequently has little or no sexual sophistication and generally little or no basis of comparison in sexual experiences. Having listened to adult molesters testify in many cases, it is clear that the child may not appreciate the criminal or wrong nature of the sexual act. This gives the offender further protection from discovery. Children are also more susceptible to gifts or other forms of intimidation which ensure their cooperation, confidence, or secrecy. Children almost always want to feel as if they have the approval of an individual who is usually older and perceived to be more powerful at the time of the abusive incident. The child will continue to seek reinforcement of this approval through continued cooperation or a bond of secrecy. The sexual abuse or exploitation of kids is usually not episodic for the abuser. It tends to become his or her regular form of sexual activity, although isolated acts of abuse do spring up from time to time. Court resolutions of child abuse are especially difficult for the victim. In the strange, adversarial settings of the courtroom, the child must not only relate, at some point, the incident itself but is subjected to cross-examination by adults who are fulfilling their obligatory roles, such as social worker or defense counsel. The result is that the victim finds the courtroom appearance to be an extension of the abusive act. The basic structure of the entire legal/judicial system has the added caution of not wanting to create any error at any stage which might result in that thing all judges abhor, WHJCH is reversal by an appellant court. Over the past 15 years I have listened to, prosecuted, served as guardian ad litem in, or presided over scores of cases of child sexual abuse and exploitation. The following are 4 capsule summaries of some typical cases, told in the present tense. Todd. Todd is 9 years old. He does not remember a time when he was not sexually abused by his father, mother, and even by groups of adults and other children. Todd's parents are members of sex clubs whose express purpose is to have sexual experiences with children, either their own or others. He is diagnosed as being socially retarded because he has not been allowed to develop the usual, normal childhood relationships common for most children. Isolating abused children from their peer groups is a means used by many offenders as a form of protection from arrest. Todd is the oldest of 3 brothers, all of whom have been abused in a similar fashion. The boys were all removed from the parents several months ago. Each has been in specialized care in a group home, with daily therapy sessions. After many weeks of confusion, feelings of guilt, for putting mommy and daddy away, and some predictable incidents of sexual acting out with older youths in the group home, the boys are coming around. Everyone concerned feels it will be at least another 6 months before Todd and his brothers can be considered for permanent placement with adoptive parents. Kathy. Kathy is 13. Her birth father abandoned the family 9 years ago. When her mother married Jim, Kathy accepted the new family unit well. Kathy's mother is a nurse who works night duty. Jim is engaged in real estate and insurance sales, a person well thought of in the community. Since Kathy was 10 she has slept with Jim on the nights her mother worked. At first Kathy felt loved, secure, and special sleeping in her parents' bed. The fact that Jim slept in the nude and insisted that Kathy do so did not at first seem to be of any great significance. Jim soon began to insist that she give him rub-downs like your mum does to people in the hospital. This request almost immediately progressed to mutual masturbation and requests by Jim for Kathy to perform oral sex on him. She was, in Jim's words, getting to be such a beautiful woman that he began to photograph her, beginning with various stages of undress and leading eventually to nude photos. Law enforcement agents later seized more than 220 photographs of Kathy taken over several years. Jim was prosecuted and imprisoned. Kathy's mother placed her in a group home after the trial, convinced that her daughter had somehow seduced Jim. I was Kathy's appointed guardian ad litem. She told me several times that she regretted ever having testified against Jim. His threats that they will come and take you away and your mum will be upset at you appeared, from her point of view, to have come true. Kathy felt as if she had ruined her mother's marriage and that it was she who had abandoned the family. Christopher. Christopher is 16. His first exposure to sexual exploitation occurred at approximately age 8 to 9. He began playing tickling games with his mother and 2 of her adult friends, a male and a female. Rob, the male, owned a photography studio. Hundreds, possibly thousands, of commercially produced photographs and films of these sessions of tickle games of 3 nude adults and 1 male child were made and sold by Rob. When Christopher was 14, he was taken into custody by juvenile court authorities and charged with the sexual assault of a 4-year-old girl and a 17-month-old boy. He will be in a correctional facility for juveniles until he turns 18. The prognosis by his psychologist is not good. I have always wondered at the meaning of the term correctional facility. It may well be the law's greatest misnomer, especially in dealing with exploited children. Benjamin. Benjamin is 12. He was befriended by a next-door neighbor known as Uncle Steve. Uncle Steve is 47 years old, married, and the father of several children. Steve began his abuse of Benjamin by giving the boy gifts of money and trips to baseball games or the soda shop in exchange for anal intercourse and silence. Steve is an executive with a large corporation. He also coaches junior league sports for neighborhood boys and has been active in church, a country club, and an international men's service organization. Benjamin's parents apparently knew nothing of the abuse until a school nurse noticed stains on his white tennis shorts. Benjamin was examined by an astute physician that same afternoon, who asked all of the right questions. He impressed upon the boy the importance of telling the truth so that he could be properly treated. Ultimately, Steve was prosecuted but not convicted. The foreman of the jury, 6 men and 6 women, later disclosed that they simply did not believe a man of Steve's reputation would do such a thing to a child. In their opinion, Benjamin was lying. As these cases indicate, much remains to be done in the name of child advocacy. At both state and federal levels, it is clear that we need more uniform statutes dealing with exploitation, from the initial reporting of an incident through the disposition of the case. The courts and legislatures have made some progress, for example, permitting testimony by videotape, allowing social workers or healthcare professionals to testify to hearsay interviews with the children, and using anatomically correct dolls which enable children to reenact incidents of abuse. Some states have presumptive sentencing for those convicted of child abuse or exploitation. Others have sought more meaningful regulations for child care facilities. 3 basic problems confront advocacy efforts and judicial reforms. First, the sexual exploitation and trafficking of minors remains a topic which is not sufficiently discussed. It is still an unpleasant subject for many adults and professionals and one they would, apparently, rather ignore. Second, children have little political power or influence, they are a constituency without a voice in our judicial system. And, third, the constitutional rights of the abuser, such as the right to confrontation and the standards of due process, must be addressed in a more pragmatic manner if realistic innovations are to survive judicial review. The rights of the victim, in short, must be given at least as much attention as those of the offender charged with exploitation. Conclusion. The federal response to sexual trafficking has been erratic and slowed by the lack of public awareness that the various child sex markets, private and public, constitute a major threat to the welfare of our youth. Renewed enforcement efforts by U.S. Customs and Postal authorities, the passage of legislation by Congress, and the creation of a National Center for Missing and Exploited Children are the 3 most recent federal responses to trafficking. In addition, recent initiatives by Congress, such as amending the RICO statute, racketeer-influenced and corrupt organizations, to extend coverage to sexual exploitation of children, as in the case of showing evidence of a child pornography scheme, and the passage of the Child Sexual Abuse and Pornography Act of 1986, may lead to heightened public interest in such activities. What effect these measures will have on the volume of exploitive activities remains to be seen. Most states have followed the federal example by enacting statutes that deal with exploitation outside the domain of intrafamilial abuse. The common feature of these assorted efforts has been a lack of perception of the fundamental dynamics of trafficking and the failure to formulate appropriate penalties for the crimes involved. The one connective thread between federal and state legislation is the issue of child labor, from which has sprung a profusion of statutes and amendments designed to protect minors in the workplace. Although restricted primarily to work issues, these laws have prompted improvements in peripheral areas such as child abuse and child neglect, and they have also compelled legislatures to take a broader view of the rights of minors in a variety of unrelated areas. With the introduction of juvenile courts and the slow development of a juvenile justice system, we have seen the advent of comprehensive statutory programs. These programs, while often criticized for their displacement of family rights, have at least provided the means for a state to intervene in cases of child exploitation or abuse. Such legislative actions will not eliminate the crimes of sexual trafficking, but at least they reflect a change in attitude in state government and Congress from one of complacency, based on gross ignorance of the problem of sexual exploitation of minors, less than to one promoting judicial advocacy for those who cannot otherwise find representation or aid within the political system. Endnotes. 1 Fair Labor Standards Act, 29 U.S.C. 201 to 219, especially 212, Child Labor Provisions. 2 Arizona Revised Statutes Annotated, Chapter 200. 3 McKinney's New York Penal Law, Title 0, Article 262, Sexual Performance. By a minor, commentary. 4 May v. Anderson, 345 U.S. 528. And Meyer v. Nebraska, 262 U.S. 390. Natural duty of parent to give his children education suitable to their station in life. 5 Jackson v. Indiana, 406 U.S. 715, 738, 32 L.ed 2D 435, 450, 92 SCT. 1845. 7 Hammond v. Department of Public Assistance, 142 Watt. Virginia 208, 214, cited cases omitted. 8 See also Ginsburg v. NY, 390 U.S. 629 640, 20 L.ed 2D 195, 204, State has interest to protect the welfare of children, and Stanley v. Illinois, 405 U.S. 645, 552, State has the right and duty to protect minor children. 9 Robert E. Buchholz, Jr., ed., Constitutional Limitations on the Scope of Child Neglect Statutes, Columbia Law Review, Vol. 79, No. 4. Pages 719 to 732. 10 New York U. Ferber, 458 U.S. 747, 73 L.ed 2D 113, 102 S.ct. 3348. 11 United States v. Reedy, 632 F. Sup 1415, 1416. 12 David P. Shovlin, Preventing the Sexual Exploitation of Children, a Model Act, Wake Forest Law Review, Vol. 17, p. 538. 13 Andrews Edward, ed. Concise Dictionary of American History, p. 176. 1429 U.S.C., 201 to 219. Fair Labor Standards Act of 1938. 15 New York v. Ferber, 458 U.S. 747, 753, 73 L.ed 2D 1113, 1120, 102 SCT. 3348. 16 Ibid. 17 S. Representative No. 95 to 438, 96 CONG, 2D Session 5 to 6. 18 HR Report No. 98 to 536, First Session 2. Reprinted 1984, U.S. Code Cong. And Admin News, 492 to 494. 19 United States v. Miller, 776 F.2d 978. 10 PUBL No. 98 to 473, 42 U.S.C. 5771 ET. Sec. Missing Children's Assistance Act. Il Fact Sheet for the Honorable Alphonse M. D'Amato, United States Senate. United States Government Accounting Office, P5. 12 PUBL No. 98 to 473, 18 U.S.C. 16, Crime of Violence Defined. 53 Cal Penal Code, 1000.30 to 1000.36. 5428 USC 994, D. SC, for example, Stanley v. Illinois, 405 US 645, 92 SCT. 1208, 31. L.ed 2D 551, Parham VR, 442 US 584, 602, 99 SCT. 2493, 61. L.ed 2D 101, 119. S6. Contributed by the Honorable Lyerly, Banner Elk, North Carolina. 17 on October 18, 1986, the Senate passed S. 985, amending the RICO statute. President Reagan signed H.R. 5560, the Child Abuse and Pornography Act of 1986, PUBL. No. 99 to 628, on November 6, 1986.